Welcome, I am the Loud Little Ducky. Today we are finally getting to Gillespie versus Owens, or Owens versus Gillespie, whichever one it is. Part 3. I did a video and posted it prior to this video going over what the Arizona laws of abortion coercion are. If you want to check that video out, it is in the Gillespie playlist. I will also link it down in the description box below so that you have a better understanding of some of the arguments and things that are going on in this particular case, because that is what Owens has accused Greg Gillespie of doing it. So let's jump right in. Hit that like button, subscribe, turn your notification bells on, and let's get into it. So first up, we are going to September 24th, 2021. Woodnick Law posts in the Superior Court of State of Arizona in and for the County of Maricopa, Owens and Gillespie motion to dismiss assigned to the Honorable Judge Bacchus. Defendant Gregory Gillespie, by and through undersigned counsel, hereby respectfully moves to dismiss plaintiff's complaint pursuant to Rule 12b-6 Arizona Rules of Civil Procedure, as plaintiff has failed to state claim upon which relief can be granted. As and for his motion, Mr. Gillespie states and alleges as follows. Number 1. Upon information and belief, plaintiff is not pregnant. How many times has Woodnick had to write that statement about Owens? Like, I'm sure he's tired of writing that statement. He could just copy and paste it at this point. But plaintiff is not pregnant, and all claims of being alleged against Mr. Gillespie must fail as a result. Number 2, plaintiff filed her complaint on August 11th, 2021, alleging that she became pregnant with Mr. Gillespie's child on their second date. 3. Prior to filing her complaint, plaintiff provided sonographic images to Mr. Gillespie on August 6th and August 8th of 2021. However, a reverse Google image search revealed that the image were identical to a sonogram found on a blog post from 2015. Number 4. Upon information and belief, plaintiff altered the images by adding her name, date of birth, alleged location of the sonogram, and altered the appearance of the image to distinguish it from the one located on the aforementioned blog post. Number 5. To further this fictitious pregnancy, plaintiff sent Mr. Gillespie a fabricated email exchange date August 19, 2021 and August 22, 2021 between herself and a California attorneys Allison E. Cordova and Joe Cotchett of Cotchett, Petrie, and McCarthy, LLP. Tony Stevens, believed to be a legal assistant at the firm, is also CC'd on the email dated August 19, 2021. Number 6. In the fraudulent email dated August 19, 2021, Associate Allison E. Cordova allegedly emailed plaintiff in pertinent part the following, with the subject line of "re-sent on behalf of Joe Cotchett, Laura Owens pregnancy." Quote, "Everything you told us about pregnancy test results and ultrasounds aligned with the timing you provided us. There were no past pregnancies on your record, and 3 obstetricians you saw felt that pregnancy was very consistent with intercourse that took place between June 30th and July 1st. First of all, there should be past pregnancies on her pregnancy records, whatever those are, because she had maraschino and mats. So why is there no past? We discussed this in, I believe, part 2. It must feel like you have the weight of the world on you, but I have no doubt that the jury will sympathize with your situation. The next step is to fill out the attached retention agreement." Now, I don't know if this was ever going to get to a jury at the end of the day, or if it was just going to be a bench trial like what happened in the Clayton Eckert case. But we have read that email. Number 7. Subsequently, Joe Cotchett allegedly emailed plaintiff in pertinent part the following on August 22, 2021, with the subject line of "sent on behalf of Joe Cotchett, Laura Owens pregnancy." Quote, I'm ready to get started on this the second you give me the go-ahead. I'm always here for you and the whole Owens family, which is a weird thing to say. Why are you not saying you and your family or your whole family? Why do you have to put the Owens part in there? Whenever you need me, and if you want me to go after this guy, I will make this case a top priority. Shh. Because I really feel for you right now. Allison sent me over the retention agreement and the medical files. This may be very needy, and we could make this a public interest story with the snap of a finger. Number 8, in response, plaintiff allegedly emailed Joe Cotchett back on August 22nd, 2021, stating in pertinent part as follows. I think the best call is to pursue alternative service and try to get him twice, once by posting on his house door and the other by calling his company and finding a coworker to serve him. I think you're right that you would be better at making those phone calls than me. I texted you the coworkers who we could ask to serve. So, very interesting. We did go over this particular thing, and so it's just interesting. And I have been told it's not called a retention agreement. So that's something as well. Number 12, in addition to fabricating documents, plaintiff has refused to take a non-invasive prenatal paternity test, despite undersigned counsel's informing her on August 27, 2021, that they had scheduled the test for her. Number 13, which, before we get to number 13, so they scheduled the test for her. It's interesting that she is complaining about Clayton not doing his part, and here she is in this case not doing her part. Hypocritical. 13. In response, plaintiff stated she was willing to take a paternity test to prove that the child is Greg's, but that it would be possible that she would not be pregnant, as I am unsure what the purpose is, because if the pregnancy is not viable, that proves that this coercion did result in the end of the pregnancy. Essentially, plaintiff has fabricated the abortion coercion allegation to explain why a paternity test would show that she is not pregnant. Additionally, as of filing, plaintiff has not taken a paternity test despite Mr. Gillespie's repeated offers to pay for the test. So she's saying here that because of the coerced abortion, that it could show that she's not pregnant. But you're saying you are pregnant, so, and you said that the abortion coercion stuff didn't work because of the second pill and like all of that. So like her stuff, just her excuses don't make a whole lot of sense, but usually a lot of lies don't make a lot of sense, in my opinion. 14. Upon information and belief, plaintiff's allegations of abortion coercion, intentional infliction of emotional distress, and domestic violence are quite simply blatant fabrications that underlie her real intention to force Mr. Gillespie into a relationship with her. 15. In an email with the undersigned counsel on August 23, 2021, plaintiff stated he can contact me at blank if he rethinks his decision regarding a relationship and if he would like to be a part of the pregnancy decision going forward. So if he rethinks all this, she will, and is in a relationship with this, she'll drop everything if he wants to participate. But if he doesn't do what she says, she's doing all this. Who's coercing who? 16. Furthermore, if plaintiff were actually pregnant, this should be establishment action pursuant to ARS 25806, not actions for domestic violence, abortion coercion, and intentional infliction of emotional distress. 17. Finally, if this complaint is not dismissed for failure to state a claim upon which relief can be granted, Mr. Gillespie will immediately be filing counterclaims for fraud pursuant to ARS 12543. 3. Intentional infliction of emotional distress pursuant to ARS 12. Let's see what the other part of that is. ARS 12. 542.1. A request for attorney's fees and costs pursuant to ARS 12.341, 12.349, and Rule 11, Arizona Rules of Civil Procedure, and subsequent claims for wrongful prosecution of civil action when he ultimately prevails over plaintiffs regarding her claims. Wherefore, defendant hereby respectfully requests the following. A. This court dismiss plaintiff's complaint in its entirety with prejudice. B. That this court award defendant his attorney's fees and costs pursuant to ARS 12.341, 12.349, and Rule 11 of Arizona Rules of Civil Procedure. And C. That this court grants such other and further relief as deemed appropriate. Respectfully submitted. This 24th day of September 2021. Woodnick signed, sent the copies to the appropriate people. Gillespie signed under penalty of perjury that he believed all this information to be true and correct. Sworn af. So, August 9th and 17th of 2023 in Scottsdale, Arizona. August 9th, 2023, she was set to hear motions in the Greg Gillespie case. Owens, a continuance was given due to Owens getting a new attorney, the day before this hearing. So on the top left-hand side, you have Judge Bacchus. In the middle top, you have Owens' attorney. And then the guy that has the biggest screen panel on the far right, he is an attorney for Gillespie. Then you've got Greg Gillespie in the middle bottom, and on the left bottom we have Mr. Greg Woodnick, who we all know. So that is the people that were in the hearings. So they come back August 17th, 2023. Mind you, these things were filed like a year ago in 2022. But now, after the continuance Owens got from her new attorney, then they're set to hear the motion to dismiss and the motion for judgment on the pleadings that were filed February 15th. Owens was not on either of the Zoom hearing calls. Her attorney quotes the law on Arizona's abortion coercion, and how he thinks that those statutes do line up with what Greg has done to Owens in him and his client's mind. And Owens' attorney also talks about the mean tweaks that in her mind that this is coercion. Interesting though, Greg Gillespie's lawyer notes that there was no threats or actions of harm or violence. Like, he wasn't threatening to hurt her, he wasn't hurting her, or anything like that. And then Owens' claims are based on things that said after the said abortion had been taken place. So it can't be coercion after the fact. So we read through, and I believe that was part 1, all of these texts just going in circles and circles and circles. That she's like, well, I took the first one. Well, I didn't take the second one right, so I need to take the second one, and da-da-da-da-da. And she had already taken it, and then also Greg had blocked her after she supposedly took the pills. Said she took the pills. So everything that Greg said after the fact, that he thought she had taken the pills and everything else, he didn't start just saying the nasty things until she was going in circles to him. Obviously he had stated he wanted her to get an abortion, he didn't want to have a child with her, and told her, yeah, sure, we could be in a relationship or date or whatever. Of course he didn't mean those things, but those are things said in a private conversation. But he didn't coerce her into it. But she's saying all these things that he said to her, and him blocking her and everything, those things were not said to her until after the abortion had already started. She had taken the first pill, or said she took the first pill. That's when all of these mean messages and things that she's using in this abortion coercion lawsuit are from. So he says, how can you coerce somebody into something if they've already done the something? And that's very true. That is a very good fact. It says the acts that caused the abortion were the acts of Owens alone, without Gillespie even around. She went to the abortion place on her own. She was by herself when she took those pills, the right way or the wrong way. Gillespie was not around for that. So he couldn't force her to take those pills. He didn't force her or drive her to and said, you better do this, da 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 da. She did that all on her own. So her acts are what caused the abortion. Because if she wouldn't have done all those things on her own, they wouldn't have happened. And Gillespie wasn't around for any of it. And then they state that they don't even know who she saw to get this abortion, she is claiming. They don't know who the doctor is. He's not joint on this abortion coercion. He's not referenced. They don't have any information on who she saw to get this abortion, where she got the pills from, anything. And then eventually this case does get dismissed by Judge Bacchus on October 12th, 2023. So just 2 months later, within, I guess, the 60 days, she said, no, we're dismissing this case. Owens is not going to get to go after abortion coercion. There's not enough here for her to win on that. On October 7th, 2023, Owens later claims Greg Gillespie, his lawyer, and his California law firm hacked into her account and released the fake sonogram, all while blaming others for her problems. She basically admits these images are fabricated. So here we have Owens v. Gillespie, Woodnick files in the Superior Court of the State of Arizona in and for the County of Maricopa on 10/7/2021. Motion to strike petitioner's declaration of fraud, perjury, impersonation, extortion, additional illegal actions taken by the defendant and his counsel. And this is assigned to Judge Bacchus. Defendant Gregory Gillespie, through undersigned counsel, requests the court strike plaintiff's declaration of fraud, perjury, impersonation, extortion, and additional illegal actions taken by the defendant and his counsel. Declaration pursuant to Rule 7.1F1 Arizona Rules of Civil Procedure. Number 1. On August 11th, 2021, plaintiff filed her complaint alleging abortion coercion, domestic violence, and intentional infliction of emotional distress. Number 2. Defendant filed a motion to dismiss on September 24th, 2021. 3. Plaintiff filed a non-rule conforming motion to seal on September 24th, 2021, just hours after receiving defendant's motion to dismiss. Number 4. Plaintiff filed her declaration, air quotes, October 4th, 2021, also non-rule conforming. Number 5. The declaration must be struck pursuant to Rule 7.1F1. Number 6. In her declaration, plaintiff alleges, among other things, that A. Defendant and counsel fraudulently drafted emails between plaintiff and a law firm in California. B. Defendant and counsel impersonated a California attorney. C. Defendant and counsel were involved in extortion. And it gets better. 8. Further, in plaintiff's relentless attempts to blame defendant for documents she fabricated, plaintiff has inadvertently admitted that the documents are indeed fictitious. Number 9. If petitioner is pregnant, the remedy is found in ARS 25803. 10. Striking the filing is proper pursuant to Arizona Rules of Civil Procedure 7.1 as ARC, which is Arizona Rules of Civil Procedure Rule 7.1 F1, provides the court may strike any part of the filing that is prohibited or not authorized by specific statute, rule, or conduct order, or court order, not conduct. Sorry. We're always talking about her conduct. Court order. As this is not permitted pleading pursuant to ARSCP Rule 7, it must be stricken. Number 11, Rule 11 sanctions are warranted. Although defendant is not formally seeking ARCP Rule 11 sanctions at this time, he reserves the right to seek sanctions if plaintiff's vexatious litigation continues. Wherefore, defendant hereby respectfully requests the following. A, that the court strike plaintiff's declaration of fraud, perjury, impersonation, extortion, and additional illegal actions taken by defendant and his counsel. B, that this court award defendant his attorney fees and costs pursuant to ARS 12341, 12349, and Rule 11, Arizona Rules of Civil Procedure. And C, that this court grant such other and further relief as deemed appropriate. Respectfully submitted, this 7th day of October 2021, signed by Greg Woodnick, and copies sent to the appropriate people. Now we have October 29th, 2021, the order of protection against Greg Gillespie claims made. This is from Nut & Butt Tea timeline. I will link the timeline in the description box along with this video. It is great. JD is claiming that Gillespie somehow rendered her computer useless, and after 3-hour call to Apple, it was referred to be serviced. She also claims that there was an app installed on her iPhone called Team Viewer, which gives control to the phone and the computer, which is completely false. The Team Viewer had to be downloaded by the Apple ID that signed in on the phone. Two-factor security doesn't allow somebody to just download an app from somewhere else. It has to be done on that device, and Team Viewer can only be remotely used with a notification to the target phone and approval. You can't remote into a Mac computer from it app that's on the phone, so this entire claim is false. And then I know that for a fact. Exhibit 1 in link. November 9th, 2023. Owens' lawyer argues against Gillespie's counterclaim due to no proof of damages. He just lost money due to not being able to work on the emotional distress he is claiming. So they are back in court on, both of them are suing each other for intentional infliction of emotional distress. So Gillespie's claim, claiming it wasn't due to emotional distress. It was just for him not being able to work, that he lost money that he would have gotten if he would have worked. He wants $50,000 for lost income due to the lack of sleep and emotional issues Owens has caused him. Gillespie's lawyer mentions the fact that Owens is no stranger to the court and has brought no less than 3 cases with similar fact patterns regarding pregnancies. Because at this point, we know about Clayton. So Gillespie knows about Maraschini, himself, and Clayton, and the pregnancy claims. Because this is taking place in 2023 in November. And Clayton and Owens stuff happened in May of 2023. So she's still dealing with Gillespie stuff while dealing with Clayton stuff. With similar fact patterns regarding pregnancies, it is stated in a hearing that intentional infliction of emotional distress is the only surviving issue. Abortion coercion was dismissed. Owens' late disclosure of a rash photo was entered. That has never been mentioned before, and she is blaming Greg for it. I think the rash may have been due to, like, maybe she got hives or something because of stress, like, but that, like, we don't have anything else to go with it. She wants $40,000 for trauma suffered, anxiety, loss of sleep, etc. Gillespie says there is no physical manifestation of symptoms from anything that has happened, and then the judge has decided that neither cases meet the standard for intentional infliction of emotional distress. I am sure that they are both under a lot of emotional distress. Owens has inflicted this intentionally on all these men, in my opinion. Some may not agree with me, but that is my thinking. But it is so hard to get intentional infliction of emotional distress. It is a really, really hard claim to win on. Like, you have to have so much, and it has to be so abhorrent and outrageous for people to win this. And you have to have tons and tons and tons of proof. But, so this was dismissed. So now the abortion coercion has been dismissed, and the intentional infliction of emotional distress has been dismissed. So nothing has happened with those two cases. Now, November 12th, Owens has filed a petition for an order of protection against Greg Gillespie, and Judge Duty grants the order of protection on the same day. So, Duty has granted her 2 orders of protection. He is the one who granted Gillespie's. He is also the one that granted her one against Eckhart with the fake sonograms and stuff. So Judge Duty just falls for many, many women's crisis. Like, it's, but a lot of orders of protections, especially with women, they are granted so easily because they do not want to be the reason that a person ends up dead. But when you can verify it with fake stuff, it's like, come on. Judge Duty didn't even want to look at it in Eckart's case. I don't fully know about the Greg Gillespie one. So, in November 12th in 2021, I'm sorry we have to jump around so much because things were filed and then they were drawn out, because we know Owens likes to draw a lot of things out, and things like that. And I'm trying to follow a timeline, but it's so hard because when we get the information and things are done about it and you get information on that particular thing, it's way after. But hopefully you still get the idea of the story with everything. So here we have this filing, and it is filed, of course, November 12th of 2021 in the Superior Court of Arizona. Defendant is Gillespie, and it is for the order of protection, and it's got the case number. So, number 1, defendant / plaintiff's relationship or relationship between defendant and minor person in need of protection. And she checks off romantic or sexual relation, past or present, because that's the kind of relationship they were in. And then we go to number 4, tell the judge what happened and why you need this order. Print both the dates and a brief description of what happened. If there is a contested hearing, a judge can consider only what you have written here. Note, defendant will receive a copy of this petition when the order is served. So, they're letting them know that whatever you're accusing these people of, that person is going to get this thing with all the allegations on them. Use additional paper if you need it. So, approximately On June, we're going to kind of get a timeline here. June 30th of 2021, Gillespie and I were involved in a brief romantic relationship that lasted about 5 dates. From that relationship, I became pregnant. Mr. Gillespie, the login information for my computer, email, and everything else I have passwords to online. When he demanded my login information to my One Medical Patient portal to confirm my pregnancy, he has used that information to stalk and harass me. Okay. August 11th, 2021. On August 11th, 2021, I filed a lawsuit against Mr. Gillespie in which I, pro se, sued him for domestic violence, intentional infliction of emotional distress, and abortion coercion. This request for a PO has nothing to do with the current litigation whatsoever. The hell it doesn't. Okay, whatever. And as a last resort, since he will not listen to law enforcement calls to ask him to stop contacting me despite me making 3 police reports against him. In text messages between the two of us, Mr. Gillespie told me that he would make my effing life a living hell if I did not take the abortion pills. Take the effing pills. And that he would call the police if I showed a moment's hesitation in taking them to force me to do it. So you're telling me you sat there and said that this had nothing to do with emotional distress or abortion coercion. But here you are quoting lines of what you're claiming to be the abortion coercion. So don't sit here and say this has nothing to do with that when it clearly does. You contradicted yourself in the same paragraph on the timeline. 10/26/2021, on October 26th, I received an anonymous message from somebody saying they were hired to hack my podcast website and my personal number, asking me, what did you do to him and what did you do to offend him? Hackers just be reaching out now? Like, really? It's okay. That's weird. Do you have proof of that? Like who is this person that contacted you? Or is this just you emailing yourself? Because I don't know anymore. And then we have the October 29th, 2021. This is where she talks about an app on her phone. Says, on October 29th, I was unable to log into my computer. After 3 hours support call and an in-person visit on that day, Apple determined that the computer was going to need to be cleared. The computer stored extremely important information for the civil case that I'm involved in against Mr. Gillespie that has not been presented at trial, which he, of course, knew. While Apple was unable to fix my issue, I hired a data recovery specialist to save the information that Mr. Gillespie tried to corrupt and was successful in my efforts. It was also determined that my iPhone had an app on it called TeamViewer installed, a remote access to remote control software that allows a remote user to control iPhones and computers. Given that I am self-employed, I have never needed a software like this. I called the police to inform them of this incident on 11/1/21. You cannot put apps on other people's phone. Like, I can't go log in and download an app because you need a password, a fingerprint, a Face ID. You need something. Also, could Apple have downloaded this TeamViewer to gain remote control access that you needed on the support call when they were trying to look at your computer? Because when you're on a support call, they usually have something so that they can take over your computer and check into things. So that is my guess. So that is just, it's just weird. Let me see. Used for. It says Team Reviewer is a remote access and support software that allows to connect and control its flagship product. one solution for remote support, remote access, and online meetings. It allows you to assist customers remotely, work with colleagues from a distance, stay connected with own devices, and assist friends or family members. So maybe when she was on the support call, that is what they used. Apparently it's attached to a couple of scams. And it shows up on computers. So I don't know. But that's I don't deal with Mac, so if you download something on your iTunes Mac computer, could it show up as an app on your phone? Anybody in IT know? Let me know. Also, on October 29th, 2021, between 10:29 and 11:08, there were several instances of bizarre text messages on my devices designed to engage me, which I chose not to do. I was also logged out of my Facebook, Instagram, and Twitter accounts due to suspicious activity. Okay. November 6, 2021. On November 6, 2021, at 3:37 p.m., I received a text from a number I did not recognize with a photo of a man who looked to be in his 20s alongside his mother, who was holding a Happy Mother's Day sign. I asked who it was and was told, "Must be wrong number. Sorry, dude." After research online, I confirmed that the man in the photo is a Mr. Gillespie family friend through his cousin. This incident can be traced back to Mr. Gillespie, and combined with all the other acts of stalking and harassment has frightened me to no end. What? I wonder what Greg had to say about that. Does she, maybe he had that picture of a Happy Mother's Day sign or something, and it's maybe was posted on his Facebook or something, and maybe she went on there and got it and then has sent it to herself. I don't know. I wonder this because I want to know all the stuff in regards to that, but who knows. So 11/7/2021, I spoke with the Scottsdale Police Department 11/7/21 and was told that another woman has an active order against Mr. Gillespie that she filed for in September. I know this woman to be his ex-girlfriend, who he told me he had tracked on her Apple Watch in December 2020 in order to prove that she was cheating on him. When he discovered she was, he admitted to grabbing her arm and snatching the watch off. I do not know what has happened between them since, but there has clearly been an additional issue. Mr. Gillespie has also told me about how he had been accused of harassment by a coworker who I met while we were out to dinner. In 5 dates, you got to know all these people in Gillespie's life. Now, I don't know about that other woman. I don't know what Gillespie's past is. But the only thing that I am confident in is that the pregnancy claims by Owens were not real. I don't know about any other claims in his past. I haven't heard from any of those people. I haven't heard from Greg on those things. He might have a temper. I don't know. My thing that I cover and that I am justice for Greg on is in the pregnancy matters with Owens. Anything that has to do with anybody else, I have no information on to even make an opinion on it. So, and then says June 30th, 2021. Despite knowing that I am a domestic violence survivor and a public speaker on the topic, Mr. Gillespie previously put his hands on my throat, and this would have undoubtedly led to something more had I not stopped him. He is 6'4", and while I am 5'5" and weighs more than double what I do not stand a chance against him. why didn't you put that up there with the other 6:30 information you had? Why are you just now putting this down? You didn't stand a chance, but you stopped him? Now, I hope Mr. Gillespie isn't out there putting his hands on people. I really hope he's not. And if he is, or he didn't know his strength when he took a watch off of somebody, you know, when you're getting cheated on, sometimes you make bad decisions. And he may have reacted in a way he shouldn't have. Oh wait, a woman. Yeah. So, yeah. I don't know why Owens, after all this, everybody she's with assaults her. And she's scared of everybody. Like, what is the max number? I mean, I know there's not a max that you can have, but I wonder, like, what people, like, I know there are women that they just choose badly. And they get themselves into awful relationship after awful relationship, and they might have some thing, but I just, like, these people do this to her, and she begs them to be with her, and, like, if he does these things to her, then why does she want to, like, make him be with her, or be in a relationship with him, and go away on vacations together to Sedona, and everything like that? It just, I don't know. And the abuse thing is so weird, but it's also hard to believe things that Owen says without any proof. And that's why I don't want to speak on things that I don't have proof about. That's what I'm saying. I hope Gillespie didn't do these things. So 11/12/2021. I am asking the court for this injunction because I fear for my life. Mr. Gillespie is a manipulative and dangerous person and has been incessantly harassing me. I believe that he is retaliating against me for my pregnancy with his child and will not stop until he has ruined my life. So here she's claiming one child, but she claimed twins as well. So is it twins or one child? He will not stop until he ruined my life, my podcast, and causes serious mental and physical harm to me. He has shown me that he is an aggressive person in my brief history with him, and I am fearful to be outside of my home alone. I pray that this will make him understand the consequences of him tracking me by a cyber stalking or otherwise. Knowing how much I did not want to have an abortion, he forced me to take abortion pills so that his own child would not be born. And in doing that has shown a complete lack of care for human life or empathy for me. I'm unsure if even a protective order will stop him, given that he has chosen to ignore law enforcement's warning to stop cyber stalking and harassing me. I would like to see what the police have to say about that. Like, we got to see what some of the police things said in the Maraschini case, because she called the cops on him all the time too. But she was afraid to leave her house, and she can't sleep in her own bed because of the things done to her in that bed. So if you're not going outside and you're afraid of everything with Michael Maraschini, you now are saying that it's not Maraschini, it's Gillespie. But then in court, just the other day, when you were in court, you made sure that you called 911 on Maraschini. Greg was there too. And he's just this scary, scary guy, right? But you didn't call 911 on him. Are you not as scared of him as you are Maraschini? Like, why do you have a problem with one and not the other? Like, I don't know the game you're playing. She says, however, I am desperate to get him to stop and understand the consequences his actions will have if he continues. Your Honor, Mr. Gillespie is extremely dangerous man, and I have no other remedy than to ask the court to enter an order of protection and other relief as I deem necessary to ensure my safety. And then the sixth thing says, this defendant should be ordered to stay away from these locations at all times, even when I am not present, and she puts resident on there. Number 7, defendant should be ordered not to possess firearms while this order is in effect because of the risk of harm to me and other protected persons. And then it is signed. So then we have order of protection. So this is where it's been granted. It's for Gregory Gillespie. And on behalf, warning to defendant. This order shall be enforced even without registration by the courts of any state, the District of Columbia, U.S. territory, and may be enforced by tribal lands crossing state, territorial, or tribal boundaries. To violate this order may result in federal imprisonment. Because of this order, it may be unlawful for you to possess or purchase firearm or ammunition pursuant to federal law or state, tribal, territorial, or local law. If you have any questions whether these laws make it illegal for you to possess or purchase firearms, you should consult an attorney. Only the court in writing can change this order. This order is effective for 1 year from date of service. No contact. Defendant shall have no contact with plaintiff except through attorney, legal process, court hearings, and as checked. Protected locations. She is protected from resident. He cannot go to her residence. And it is signed. Nothing to the plaintiff can stop, change, or undo this order without the court's written approval. You must appear in court to ask a judge to change, modify, or dismiss or quash this order. Even if the plaintiff initiates contact with you, you could be arrested and prosecuted for violating this order. If you do not want the plaintiff to contact you, you have the right to request a protective order against the plaintiff. But orders are not automatically granted upon request. Legal requirements must be met. If this order gives you exclusive use and possession of a residence, Okay, so Judge Duty signed it. I don't even know if he had a hearing on it. He was like, yep, that sounds bad. All right, here you go. And then it shows that the order of protection was served. Romantic. Oh, I guess here's part of something else. This is 11/15. Okay, and it says February 8th, 2022. On February 8th, 2022, I received messages from an unknown number. The sender identified himself as Danny Hutzler, and while I don't recognize the name immediately, an Instagram search showed me that it was a former baseball player of the Chicago Cubs who I contacted once in June 2021 after seeing him on a dating app, which was right before I met Mr. Gillespie. It soon became clear that I was not communicating with Mr. Hutzler, as the sender repeatedly referred to coming to Scottsdale to pitch for the Chicago Cubs during spring training. The real Mr. Hutzler retired from playing in 2021. I strongly suspected that this was Mr. Gillespie. Where's your proof for this? As he had made attempts to contact me before under fake identities, and no one else would have reason to commit identity theft in order to obtain information about me. Mr. Hutzler immediately and relentlessly tried to get me to meet up with him. He referenced us spending time together before, when in reality I never met up with Mr. Hutzler. The only conclusion I can make as to why Mr. Gillespie chose Mr. Hutzler to defraud over any other man in my social network is that he saw that Mr. Hutzler was the only man I had communicated with during the same time period as Mr. Gillespie, meaning that Mr. Gillespie's mind, it could have been Mr. Hutzler who impregnated me and not him. This was most definitely not the case, as I had no sexual interaction with anyone other than Gillespie from early 2020 to present day. I had not seen Mr. Gillespie since early August 2021, and he did not know whether or not I had terminated the pregnancy. I presume that this repeated request to see my body under the identity of Mr. Hutzler was to see if I had or had not. On August 11, 2021, I filed a lawsuit against Mr. Gillespie for abortion coercion and intentional infliction of emotional distress, and litigation is ongoing. Thus, the pregnancy and the status of the utmost importance to him. I continued the conversation to the fake Mr. Hutzler because I wanted to be able to have firm proof that it was Mr. Gillespie before I reported a violation of the protective order. Okay. I was able to get Mr. Hutzler to admit that he knew about my pregnancy. Outside of my parents and sister, only Mr. Gillespie, his legal counsel, and my legal counsel know about it. I moved from San Francisco to Scottsdale in early 2021 and have not developed friendships as I have been extremely nervous about leaving my home and encountering Mr. Gillespie. Oh, because she's moved to Arizona, so she's not afraid of Maricini anymore because he's not in her state. She moved states. Mr. Gillespie, given his prior threats and behavior towards me, in addition, Mr. Hutzler referenced my restraining order against Mr. Gillespie, which, again, I have not told anyone about. Among the texts sent from the fake Mr. Hutzler, he didn't want to kill you. He wanted to kill the baby. Not sure I made that clear. He was asking for photos of my body, brought up my protection order against Greg, said he was going to make me see stars and that I deserved a spanking for being rude. And that was into violence when he was into violence when he was turned on. He repeatedly begged me to meet up with him. Again, this was confirmed not to be Danny, and no one else would know anything about my past with Greg, let alone be wanting to discuss it for 3 days. Where's your proof on all of this? Like, this can be verified by people. Like, what the hell? Like, she likes to make up fake people, so how do we know she didn't do this? I mean, how do we know Greg didn't either, but like, she's known for making up fake people. Give me the IP addresses. Like, somebody get the IP addresses and look at this. February 22nd, 2022. I noticed that my public Instagram story for my personal account was getting watched a lot by accounts with no photos and followers. I came to suspect that this was the defendant. I created stories using pins or of quotes from Pinterest that were only viewable to accounts I suspected were him, blank, 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 and blank. On February 22nd, 2022, the date used for the date of the incident, I sent the initial disclosures for civil case we are involved in, case number. He included 10 pages of screenshots of the Instagram stories that were only viewable to him, proving that he was in fact using the pseudonyms listed above to view my account. These despite the order of protection granted on November 11, 2021, case number, which states in part with capitalization added here for emphasis on relevant statements. Do not access any part of the plaintiff's computer, phone, or similar device, or any account. That he didn't go into your account. If he's looking at it on Instagram from his own phone, that's not him going into your phone or computer, but okay. Like, that makes no sense. In addition, it specifically orders the defendant to not make any attempts to track the plaintiff's whereabouts. And he knew that there was significant chance that I would have geotagged my location on those stories. Well, if you're scared, you wouldn't be geotagging your location. Sorry. You wouldn't be putting your location out there if you were worried about somebody coming to you and finding you somewhere where you're not expecting it. She did this in Maricini case too, where she was going these places and tagging herself on Instagram, and it's like, but you don't want to be found. You're scared of somebody coming after you and killing you or hurting you, but you're going to tag and put all your information out there. It makes no sense. And she knows that she does this, so it's not, she can't even say that I didn't know I had my geotagging on, or I didn't know I tagged locations, or it said that. She clearly knows that she geotags these things. July 3rd, 2022, the defendant blatantly viewed my Instagram story under his own username. Name blank. Despite the court's orders stated in the detail above, making my Instagram private would be detrimental to my business, which combined have nearly 35,000 followers. The defendant simply needs to stop cyber stalking. Your personal Instagram and your business Instagram should be separate, for one. Some people's aren't, but they should be separate, so that you can have your private life and then your business stuff is something different. 5. The following persons should also be on this order. And it does say, number 6, defendant should be ordered to stay away from these locations at all time, even when I am not present. Residence, work, business, school, other. 8, defendant should be ordered to stay away from any animal that is owned, possessed, leased, kept, or held by me, defendant, or minor child living in either my household or defendant's household. Okay, so she's protecting her dogs and animals once again. And then this is signed November 15th, 2022. She swore all that under penalty of perjury. So now we're moving to January 4th, 2022. Gillespie files his answer and counterclaim alleging fraud and intentional infliction of emotional distress against Owens. And February 28th, 2022, Gillespie files his response / objection to time extension. Woodnick Law, January 4th, 2022. Superior Court of State of Arizona in and for the County of Maricopa, Owens v. Gillespie. Answer and counterclaim assigned to the Honorable Judge Bacchus. Defendant Gregory Gillespie, by and through undersigned counsel, hereby files his answer and counterclaim to plaintiff's complaint and admits, denies, and alleges as follows. Answer. Number 1. In responding to paragraph 1 of plaintiff's complaint, defendant admits that the plaintiff has pled in part tort allegations. However, plaintiff's complaint also cites However, plaintiff's complaint also cites to a criminal statute, and to the extent her civil claim is based on the criminal statute, must fail as the criminal statute does not authorize a private cause of action. So if something is criminal, you got to go to criminal court. If it's civil, it goes to civil court. You can't bring criminal to civil, and you can't take civil criminal. It can be done in both, depending on the circumstances. You can have a civil claim that has to do with a criminal thing, but they are still done. They're separate things in the way you handle them. 2. In responding to paragraph 2 of plaintiff's complaint, defendant admits venue is proper for plaintiff's tort-based claims, but again affirmatively alleges that civil claims based on criminal statutes are improper in this venue and must fail as the criminal statute does not authorize a private cause of action. Number 3, defendant denies the allegation contained in paragraph 3 of plaintiff's complaint and the allegations contained in apparent subsections 4 through 9 of paragraph 3 of plaintiff's complaint. I do not have Owens stuff. I only have the Gillespie stuff. So I don't know what they're talking about until I'm shown. 4. In response to paragraph 4, defendant denies that plaintiff is entitled to an award of attorney's fees and or court costs. 5. Paragraph 5 does not require a response from defendant. However, if it is determined that it does require a response, defendant hereby denies the allegation contained in paragraph 5. 6. Plaintiff's complaint does not contain a paragraph 10. 7. Defendant denies the allegation contained in paragraphs 11 through 46 of plaintiff's complaint. 46 allegations that 46 allegations. maybe 45 because there's no paragraph 10. 8. Defendant denies any and all allegations of plaintiff's complaint not specifically admitted herein. So he says everything that she said is not true. That is what Greg says. The counterclaim. Fraud. 1. Upon information and belief, plaintiff knowingly and falsely represented to defendant that she was pregnant with the intent to force defendant into a relationship with her, causing defendant consequent and proximate injury and damages as a result. 2. Plaintiff filed her complaint on August 11, 2021, alleged that she became pregnant with defendant's child on their second date. 3. Prior to filing her complaint, plaintiff provided sonographic images to defendant on August 6 and August 11, 2021. 4. However, a reverse Google image search revealed that the sonographic images were identical to a sonogram found on a blog post from 2014. 5. Upon information and belief, plaintiff altered the images by adding her name, date of birth, alleged location of the sonogram, and altered the appearance of the image to distinguish it from the one located on the aforementioned blog post. 6. To further this fictitious pregnancy, plaintiff sent defendant a fabricated email exchange date. Okay, we did that. And that's stuff that we went over. Okay. Let's go to 10. Plaintiff alleged email exchange between Joe Cotchett and Allison Cordova with the subject line urgent copy of conversation with Joe Cotchett and contact, along with manufactured fabricated contingent fee. It should be contingency, but it's contingent fee agreement is what she labeled it as, between plaintiff and Cotchett, Pitry, and McCarthy, LLP, dated August 23, 2021. 11. Upon information and belief, neither Allison Cordova nor Tony Stevens is currently employed at the firm, nor were they employed at the firm as of August 19th and August 22nd, 2021. So they could not have sent these things to her with that law group because they weren't employed there. 12. Believing that there was fraud in plaintiff's underlying complaint, undersigned counsel reached out to the purported attorneys in California who appeared to, let's see what else it has to say, appeared to completely disavow any connection to this cause as email dated August 24th, 2021, sent on behalf of Joseph W. Cotchett, indicated the firm does not represent plaintiff in this matter. All subsequent emails from undersigned counsel requested to speak with Joseph Cotchett, Uncle Joe, about the seemingly fraudulent emails purported authored by Joe Cotchett and lawyers. They have not worked at the firm for quite some time. Went without any substantive response. Number 13. In addition to the fabricated documents, plaintiff has refused to take a non-invasive prenatal paternity test. 14. Plaintiff stated as she was willing to take a paternity test to prove that the child is Greg's, but it would be possible that she would not be pregnant, as I am unsure what the purpose is, because if the pregnancy is not viable, that proves that his coercion did result in the end of a pregnancy. Essentially, plaintiff has fabricated the abortion coercion allegation to explain why a paternity test would show that she is not pregnant. Additionally, as of filing, plaintiff has not taken a paternity test despite defendant's repeated offers to pay for the test. We've already gone over that. 15. Upon information and belief, plaintiff's allegation of abortion coercion, intentional infliction of emotional distress, domestic violence are quite simply blatant fabrications that underlie her real intention to force defendant into a relationship with her. In an email with undersigned counsel on August 23, 2021, plaintiff stated that he can contact me and if he rethinks his decision and wants to play a part in the decisions going forward. 16. Plaintiff knowingly fraudulent representations to defendant, having caused defendant consequent proximate injury to defendant, is therefore entitled to recover subsequent damages in the amount to be determined by trier of fact. 2. Intentional infliction of emotional distress. So this category. Number 1, defendant hereby incorporates by reference all allegations of paragraphs 1 through 16 of counterclaim 1. Fraud above as fully set forth herein. 2. In doing so, defendant hereby alleges that the plaintiff's fraudulent conduct was extreme and outrageous and must either have been intended to cause defendant emotional distress or recklessly disregard the near certainty that such distress would result from her conduct and that the defendant has suffered from severe emotional distress as a result of her conduct. I do believe that. I believe Greg has suffered from emotional distress due to her fake pregnancy stuff that she has pulled and false documents and impersonating people. 3. In turn, defendant is entitled to recover compensatory damages in the amount to be determined by trier of fact, wherefore defendant, having fully answered plaintiff's complaint and stated his counterclaims, hereby respectfully requests the following. A, that this court deny plaintiff's complaint in its entirety with prejudice. B, that this court grant defendant's counterclaims and award defendant damages in the amount to be determined by trier of fact. C, that the court award defendant his attorney fees and costs pursuant to ARS 123341, 12349, and Rule 11, Arizona Rules of Civil Procedure. And D, this court grant such other and further relief as deemed appropriate. This was denied, this motion of the intentional infliction of emotional distress. We went over that, but this is just the documentation on it. It's sent to the right people, and Greg, signed the thing under penalty of perjury and the verification that everything is true and correct to the best of his knowledge. Now we have on February 28, 2022, response/objection to plaintiff's motion to extend time to file a response. So Owens apparently wanted a motion to extend time to file a response, which she filed in Greg's as well. Or not Greg's. She filed in Clayton's as well. She always wanted more time. Woodnick filed this, and it was in Maricopa County. Defendant Gregory Gillespie, by and through undersigned counsel, hereby files his response/objection to plaintiff's motion to extend time to file a response to the defendant's motion to dismiss. Partial motion for judgment on the pleadings. Defendant provides as follows. So we went over the court hearing and what was determined. These are the filings that go along with that court hearing that was heard like almost a year later. Number 1, under normal circumstances, routine requests for time extension should be liberally granted. A, this is not a normal circumstance nor a routine request, as plaintiff has had a history of claiming legal representation when none exists. B, these claims are part of a pattern of plaintiff's limited transparency, which are more fully detailed in defendant's counterclaim filed on January 4th, 2022. C, more specifically, as it relates to plaintiff's claims of having legal representation, on August 22nd, 2021, plaintiff sent defendant an email exchange allegedly between herself and a California attorneys, Joe Cotchett and Allison Cordova, discussing pursuing legal action against the defendant. Plaintiff attached a contingent fee agreement between herself and Cotchett, Petrie McCarthy, and LLP, dated August 23rd, 2021. That is Exhibit A. We will not be going back over that exhibit because we've already gone over it and it was mentioned in filings in this video. Upon information and belief, Allison E. Cordova is not employed at the firm and was not employed by the firm on August 22nd, 2021. D, an email dated August 24th, 2021 indicated the firm does not represent plaintiff in this matter. See Exhibit B. We have also gone over that. E, defendant asserts that 1 week courtesy extension offered is more than reasonable and enough time for an attorney to review 40-plus docket entries, many of which are briefs and not substantive in nature. Number 2, plaintiff has been aware of defendant's motion to dismiss/motion for judgment on pleadings of plaintiff's abortion coercion claim motion since February 3rd, 2022. So it is now the 28th. She's known about it since the 3rd. A. On February 3rd, 2022, plaintiff and defendant had an early meeting and specifically discussed the motion. Plaintiff requested defendant clarify the motion, and the parties spoke over the phone a second time later that day. Exhibit C. B. A draft of the motion was also forwarded to plaintiff as a courtesy on February 14th, 2022. So she's had a copy since the 14th. It's now the 28th. With a request that she stipulate to dismiss the abortion coercion claim voluntarily prior to defendant filing the motion. Plaintiff declined to stipulate. So she's had this motion. They've given her a chance to withdraw it or dismiss it herself. C. Therefore, defendant's motion was untimely filed on February 15, 2022, pursuant to Rules 6C and 7.1A3, Arizona Rules of Civil Procedure. Plaintiff had 10 business days in addition to 5 calendar days to file a response. Therefore, plaintiff's response is due on March 7th, 2022. So she was almost basically given a whole month when she found out about it on February 3rd, and she's given till March 7th to file her response. Like, that's more than enough time. D. On February 25th, 2022, plaintiff requests an extension from undersigned counsel until April 15th, 2022. So she wanted like 2.5 months to come up with a response. Defendant promptly responded by offering a week-long extension, making plaintiff's response due on March 14th, 2022. So they even said, you know what, we'll give you an extra week, which gives you like a month and a half, basically, instead of a little over a month. The court is encouraged to read plaintiff's request and defendant's response, noting that undersigned counsel inadvertently calculated the response time to be due on March 10th, 2022, by failing to include the 5 calendar days permitted by Rule 6C as referenced above, Exhibit D. E. Plaintiff's request would have her filing a response on April 14, 2022 to a motion she had knowledge of on February 3rd, 2022, and direct access to on February 14, 2022, requesting what amounts to be about 2.5 months to file a response to defendant's motion to dismiss is entirely unreasonable. Wherefore, defendant respectfully requests the following. A. The court only grant plaintiff an additional 7 days until March 14, 2022 to file her response to defendant's motion to dismiss / motion for judgment on the pleadings of plaintiff's abortion coercion claim. B. That this court grants such other and further relief as deemed appropriate. Respectfully submitted the 28th day of February 2022. Sent to the correct people. Signed by Woodnick. So, here are a couple of the exhibits. We are missing the beginning one where it's the fake conversation between Uncle Joe and Owens. So, August 24th, 2021, Greg wrote Joe Cotchett, Uncle Joe, I am confused as blank shared your fee agreement clearly confirming your firm's involvement. I accept that you're not representing her and wish she had counsel, but I have never had an opposing party share a fee agreement from a reputable law firm and then have the attorney deny representation. Perhaps I am being overly cautious. I will point out that there are a number of documents being circulated that appear to be doctored. If your fee agreement and communications with her are in that vein, I assume your firm would want to be kept apprised. Please advise Greg. And this is, okay, so that's what he sent. And then before that, he sent, this was sent from Patrice O'Malley on behalf of Joe Cotchett. Mr. Woodnick, I am a recipient of your email and we do not represent Owens in the above referenced matter. Sincerely, Joe Cotchett. Before she said this is what Greg wrote to Joe Cotchett before he said, I do not represent this person. And Greg was saying, why do we have an agreement of your fees? Which is weird. So, Woodnick originally stated, says Joseph, I am sorry to nudge, but this situation in Arizona is escalating with Miss Owens. She is continuing to communicate with our client, notwithstanding specific instructions to the contrary, and has even started contacting his employer and family members. In the middle of the night, she sent communication again indicating that she would contact the police if Mr. Gillespie did not reconcile with her. See attached email from your client entitled Criminal Charges Against Mr. Gillespie. If you are her attorney, I need to confirm that immediately. If you are appearing pro hac vice in Arizona, please also advise the name of your local sponsoring attorney is so that I can loop them into this. If your client is pregnant, we need to arrange the paternity test as my client is happy to pay for the same. Some of the document we had been receiving from your client appeared to be altered, photoshopped. In all candor, I am not sure if the letter she sent from you, Uncle Joe, is authentic. If it is, I would really like to talk to you today, as this is urgent. Greg. So he's trying to find out if Laura is represented or if she is not, and if this is a real fee agreement or if it isn't, and so forth. Have he actually written this stuff to her or not? I wish he would come out and speak, but he won't. I don't know if that's because he's knows Ron Owens, Laura Owens' father, or what, but it's just really weird that an attorney would just let somebody say all this stuff about them and them not come out and say this woman is lying, because most of the time that would happen. And he would need to write something to the court that says, kind of like Corey Keith did in the Eckerd case, this is not true, and I am required by law to let you know that this stuff that she's saying isn't true. But he hasn't come forth with candor to the court about this. He has kept quiet on this, aside from his person saying, I don't represent her. He won't comment on anything else. It's weird. So we've got this email, says, Mr. Cotchett, I represent Greg Gillespie in the Arizona paternity matter. Owens has indicated that you are her counsel and are a part of the civil lawsuit involving our client. We do have a copy of a civil lawsuit she filed without counsel that in no way comports with Arizona's Title 25 and does not appear to have been prepared by your office. Something to note also, in her order of protection, she did say she was pro se. So she's not claiming she had counsel then in her order of protection. So that's interesting. Are you representing her? With the level of rancor in this correspondence, I am being hyper careful not to communicate with a represented party. Ms. Owens has forwarded private communication from you to her regarding the situation and appears to be demanding either remuneration or reconciliation with our client. Please advise Ms. Owens that she is not welcome to contact Mr. Gillespie going forward. The parties both have counsel, and we should be able to resolve this issue without escalation. My client has requested a non-invasive prenatal pregnancy test. He has offered to pay for the same and provided information on a qualified lab here in Maricopa County. And then that is from Greg Woodnick. So he did that one on the 23rd when the other ones were for the 29th. So he's tried to reach out many times to Joe Cotchett. Thursday, February 3rd, 2022, 3:32 p.m. Mr. Woodnick. And this was good faith consultation certificate. I don't know who it's from. Mr. Woodnick, I was looking back at my notes from the call and wanted to clarify on the upcoming MTDs. I know that you have attached a good faith consultation certificate saying that you have tried in good faith to resolve the issue before the motion is filed. I am not even sure what issue you are trying to get dismissed, so we definitely haven't had a chance to discuss them yet. I am very uncomfortable with you filing that good faith consultation certificate until we do. You mentioned adding an additional party, a constitutional issue, and subject matter jurisdiction. Please let me know if and when you have more information. I don't know if that's supposed to be from Cotchett or what. I don't know what that is. This one is subject Gillespie. It says blank. Number 1, you claim to be seeking representation from law firms in the past and referenced attorneys who were no longer employed at these firms. You have been aware of the deadline to respond to our motion to dismiss / partial motion for judgment on the pleadings since mid-February. We discussed the same during the meet and confer days before the filing. 2, so maybe she sent this to Owens. Yeah, this was sent to Owens. 2, the caption of the motion. It is actually accurately and succinctly reflects the content. I am sorry you are finding it to be embarrassing and assure you that was not the intention. You are reminded that you initiated this action and listed the abortion coercion claim and even referenced criminal statutes in your prior filings. It is in the public record because you made it public record. 3, your reference to the PDA is just incorrect, which PDA is not like public display of emotion, public display of affection. This is the Pregnancy Discrimination Act. Only applies to discrimination in the workplace. It also only applies if you are pregnant. So you can't be discriminated against. 1, if you're not in a workplace being discriminated by anybody. Also, if you're not pregnant, you cannot be discriminated against pregnancy-wise. You have refused to confirm the same, notwithstanding something like 6 requests for that information. 4, notwithstanding the above, in good faith, we will agree to give you 7 additional days through March 10th to file a response. You are welcome to revise the draft stipulation to reflect this date extension and forward it to our attention for review. Greg. So that is what he sent to Owens. Owens, prior to Greg stating this, says, stipulation for extension of time to file a response on motion to dismiss, partial motion for judgment on the pleadings. Hello. I am attaching a stipulation for extension of time to file a response on a motion to dismiss, partial motion for judgment on the pleadings, since I am retaining counsel who needs time to catch up on the 40+ docket entries in the case. In addition, I ask you to file the motion or request to redact a portion of the title of your motion to dismiss, partial motion for judgment on the pleadings of plaintiff's abortion coercion claim, withdrawal of plaintiff's abortion coercion claim. This is glaringly obvious on a public docket, and while I understand that the court has ruled on the motion to seal, it is a violation of HIPAA's private... No, it is not. It is a public filing. You have to have what the document is and what you did. You don't want this out there? Don't be filing in the courts. It is a HIPAA privacy violation. Confidential health information on display like it is in the in the title. In addition, it could become a violation of the Pregnancy Discrimination Act if it remains. Oh my God. What the hell? If you do not want to redact a portion of the title on your own terms, I will ask my new counsel to pursue it with the court. Outside of deliberate efforts to embarrass me, there is no reason for Mr. Gillespie to want this non-public information about me to be public. I would appreciate your prompt response. Thank you. All the best. So she still used all the best back then. But like Woodnett said, you made this public when you filed it in public records, public courts. It is a constitutional right for this to be public. People have the right to know about what you are doing in the court system and what kind of person you are. Are you a good person or a bad person? So that's where we end with part 3. We're ending with the quote of the day. Don't put the key to happiness in someone else's pocket. Your happiness belongs to you. It does not depend on somebody else. Owens needs to find the happiness within herself, within her own life, and not try to put her happiness on men or babies. Find it within yourself. And I hope all of y'all do the same. That is it for this video, and I will see you again for part 4, which I believe is going to be the conclusion in the Greg Gillespie series. Bye!